Morning, everyone, again. I'm Sandhya Iyer from the HR department. This is part of the roundtable. We run this roundtable, we run this discussion once every 2 months, and we're usually joined by HR professionals and employment lawyers in the area. And today we've got Lyndsey Hanson from TenIntelligence. TenIntelligence is, they're one of our members. They're into some very interesting forensic support for small and medium sized enterprises. They also operate on a global level in terms of GDPR. And today we've got Lyndsey here, who takes care of the GDPR arm of that business, and who's going to be talking to us quite a bit about possible pitfalls and really how that can be avoided and some interesting stories. So over to you, Lyndsey.
Good morning, everybody. Like I just said, my 5-year-old's passed on a cold to me, so I watch. So if I do start coughing, that is why. So I thought today I'd go over with you kind of the top 10 most common questions asked when it comes to data protection and GDPR. And then if you have any questions off the back of that, then yeah, feel free to reach out and ask away. So if that's okay, I'll make a start. Oh, you're on silent. You're on mute.
Sorry, I should know better. We normally allow for the first 10 minutes for you anyway to talk about your work and what you do. And then being a roundtable, we sort of like to encourage conversation, back and forth. So yeah, fire away, definitely. Thank you.
Yeah, sure. I mean, in relation to my role here, I act as not only TenIntelligence's DPO, but I have a number of data protection clients across the world. We have a few in Dubai, we have some in the EU, a few in the UK, and they range from educational sector, which is really interesting. In fact, I was delivering an external data protection course, about 3 hours it was yesterday, to a room full of school governors. And then doing the same for financial sector, although kind of the data protection laws remain the same, they apply in a number of different ways. So it's an interesting role. I'm always kept on my toes. Everything's changing all the time. But yeah, I've been doing data protection, gosh, for 15 years now. So yeah, I think I'm one of the very few people that really enjoy it.
Yeah, I think the sheer volume of things just tends to put people off. As recently as last week, we received an SAR, and thankfully it wasn't such a humongous task. But yeah, I think the sheer volume of data sometimes can just put people off, isn't it?
It really is. I mean, funny enough, my husband, he has a recruitment business. So you can imagine the amount of personal data he holds. And, you'd think he'd know better being married to a DPO. And the amount of times I've said to him, you need a retention schedule. You need to have a retention schedule of how long you keep certain types of information. And it has to have a reason, such as, HR, there might be other areas why you need to keep information. There's legal obligation and so on. But if you don't need it, delete it. Yeah, he says. And he says, oh, Lynn, I've had a subject access request, and this guy wants his records back from 2021, so he outsources recruitment to clients. And he said, it's over 150 timesheets because we paid him weekly. Can I say no? And I said, no, you can't. And what you should have done is listened, because if you did, you wouldn't have had all of this data that you now have to provide to him. So yeah, proof's in the pudding. It's not just a best practice when it comes to subject access requests. Having your ducks in a row, it helps organisations out and cuts back the work for them.
Interesting. I'm just going to open the round of questioning, if that's all right, just with one question that I had, noted down. But since Brexit, how does GDPR, the European GDPR law, apply to businesses that are operating in the UK and maybe transferring data outside of the UK? Are are we controlled by the European GDPR laws, or is there something in the making for, just the UK? How does it work with GDPR?
So since Brexit, we used to have GDPR, and now there is GDPR and UK GDPR. It's very much the same thing. The impact that it has had is data transfers. So since that came along, we used to be able to use something called standard contractual clauses when you share data, say, outside of the UK. Now, the standard contractual clauses are invalid. You're unable to use them. So if you did want to share data, say, outside of the UK, if that country holds an adequacy decision, which under the EU it does, then you just need a data sharing agreement or a data processing agreement, depending on who you're sharing the data to and what they're going to do with it. However, if you need to share data outside of the UK to a country that doesn't hold an adequacy decision under the ICO, there's a list of countries that do and don't on the website, then what you've now got to do is complete an international data transfer agreement. And it's about 21 pages long. Luckily, part of it you can autofill, but not all of it. So it is a real task now, a bit of a pain in the backside, really, for businesses who do need to share data outside the UK. But yeah, you can't rely on standard contractual clauses anymore. You have to fill out the international data transfer agreement if the country doesn't hold an adequacy decision.
So the crux of that advice is, whenever you think you're going to be transferring data outside of the UK, always go onto the ICO website and check if that particular country is covered by the adequacy notice.
Yeah, or reach out to a data protection specialist.
Of course, yeah.
I've got a number of clients.
To complete the form, the 21-page form.
Yeah, well, that's exactly it. They come to me and say, Lyndsey, we haven't got time. Can you fill it out and get it sent over? But there's a number of different data sharing agreements. If you're sharing it to another company who has control in what it's used for their own purposes, it's a controller to a controller agreement. If it's to a third party who's simply acting under your instruction, it's a controller to processor agreement. So it really does pay to understand what the rules are with data transfers, because in fact, one of the top fines, what was it? It was Meta. They've just been fined 1.2 billion for exactly that, transferring data, and they didn't have the right safety mechanism in place.
Yeah, that was UK to the US.
Yes, it was.
Yeah.
I mean, there is something called the UK-US data bridge, but again, that doesn't mean you can just press send and share it. There's other things that you've got to do in the background before that happens.
Interesting. Any other questions from anyone? Any horror stories that you'd like to share? Anything we've learned so far since GDPR was introduced? I know there was data protection earlier, but somehow the attention or the focus on it has been so much more, isn't it, since GDPR came into effect?
Mm-hmm.
I think one of the things that I really struggle with if we do get a subject access request is, to what extent do you need to, can you share the information? So we had one last year, March last year, and the person that had been dismissed had put in a data subject access request and asked for all information regarding him, and asked for it across all communication channels, so Teams, Slack, WhatsApp, email, everything, wanted all information. It was kind of like, this is massive. To complicate the matter, he shared a name with one of the senior managers within the team as well. So it was kind of going, but how do we define which relates to him and which relates to this other manager as well? So it's then trying to filter through all that information, and where it's WhatsApps as well. And he was choosing specific senior managers. That senior manager had also been talking to this other senior manager who has the same name. So it was just a minefield.
It is. And the problem with subject access requests is typically they come from either, you know, ex-employees or clients or customers who aren't very happy. Disgruntled ex-employees, like you said, and that's exactly the same reason my husband got a subject access request, is because the client said they didn't want to work with him anymore. And naturally, communications, which may include their personal data that you absolutely have got to give them a copy of, unfortunately. If there is any personal data of anybody else in there, what the expectation is that the other personal data is redacted, which is a lengthy process. But a hint and tip as well is, if you aren't comfortable with, if you wouldn't be comfortable with somebody in that conversation seeing the conversation that you have and it includes their personal data, don't put it in there. So rather steer away from opinions and more facts, and then, you know, you can have a meeting face to face separate to that. But say if the subject access request is rather excessive, then you can extend, because you have 30 days from the day you receive the subject access request. And it doesn't matter if that's on a weekend. The 30 days will start from when it was sent. Yeah, instead of having the 1 month, it can extend up to 3 months, but just document your justification and reason for that internally. But say if there's, you know, hundreds of emails, which includes his personal data in, and it's just his email address. So you haven't mentioned his name or anything, no other personal data in the body of the emails, but there's emails that have been sent to him. You could confirm that, I can confirm there's been 150 emails across the course of this time period and that time period, and the personal data that was involved is your email address. But if any of this other personal data was included in those emails, then unfortunately, yes, you do have to provide a copy.
And is that across everything, including WhatsApp, or is personal WhatsApp sit outside of that?
It's where his personal data is being processed by an organisation across all platforms.
But are you expected to search your WhatsApps as well?
Yeah, if it's in there, then yeah, double check. So again, delete any chats that you don't need, or just don't have conversations like that with personal data in. I mean,
I guess the hard thing with this one was because the other two senior managers, the one that shared the name with him, they had lots of WhatsApp discussions. It's kind of like, it's not his personal data, but if you're searching and you search on a search term, how do you prove that you've searched and the data isn't related to him?
It's only if the actual message has his personal data in.
Okay.
And like I said, if it has got personal data, if anybody else in there, you redact it before you send him a copy. But yeah, if it's just a body of a message and it's got none of his personal data in there, you don't need to send him a copy.
I've just linked to what Gemma's just raised, Lyndsey. I've had a case where, yes, it's very difficult to go and look in every nook and cranny and ensure that you're sending all the information that is that should be covered under the SAR. And if and when that was, you know, say it's missed out, so for whatever, it was a genuine sort of, you know, oversight and one small aspect which wouldn't necessarily have a material impact on what the person was asking for, but it's still related to the SAR. Now, in that situation, the understanding is that the individual who's alleging that some part of their information has not been sent to them, regardless of whether it is material or not, they are able to go and seek a court order ordering the employer to disclose that information. Is that something you've come across, and how does that sort of, what I'm getting at is, human beings can, they can be oversight, and you might just miss out something that has to be sent via in response to an SAR. What is the worst possible implication when that happens?
I mean, the subject
in real life, what has happened?
They'd report that to the ICO, because it's a breach of a regulation. So they'd be directed to go to the ICO. The ICO would then investigate an organisation, decide whether a breach has occurred. Now, I know the breaches, it goes up to a maximum of 17.5 million, or 4% of the global turnover. However, the ICO won't always take a harsh approach like that. They look at the type of breach, the level of breach, is a fine justifiable, or is it a warning or an advisory? They don't fine you every single time, and they certainly won't fine you millions. They will weigh up the actual impact to the data subject and the level of the data breach itself. So not everybody's fined. But should you not be able to provide that information, always document your decision. You can complete a risk assessment. So that will just outline and show to the ICO that you've done your due diligence, you've taken, you've been responsible enough to comply to the best of your ability with the data protection law. So if they come knocking on your door, again, that'll go in your favour, but they're certainly not going to slap you with a fine of millions if it's low level risk personal data and it's one or two messages. But you should certainly go ahead and acknowledge the subject access request, because it is a right of every individual under the GDPR.
But in your work, you haven't come across a situation where an employer has genuinely missed out, sending something as part of an SAR, and they haven't been slapped with a court order saying, no, you've got to issue this. Because I'm thinking, based on what you've explained, the ICO would go through it, investigate it. If it's a genuine oversight, you're required to send it. Possibly if that's been ignored by the employer over a period of time, that's when you're looking at a court order, I would think.
I haven't heard of necessarily court orders, because the ICO who police data protection and the processing and people's rights, and they're the ones that will enforce fines and request that you rectify anything that they see. So they police the data protection world. But in terms of an actual court order, I'll have a look to see if there's any examples, but I've never come across that in my time.
Okay, thank you.
Can I just say, I have Lyndsey, a colleague of mine is Deputy District Judge, and I was actually discussing, he was sitting the other day and he'd come across exactly the situation, and it was borderline vexatious litigation, and he'd indeed been talking to his other judges about it, because they were saying this should not be dealt with in the courts. It's quite a system. The appropriate forum is the ICO. They're geared for it. There's a whole regime in place. There's no cost consequences. This is the wrong forum. But there did appear to be a freestanding right for an individual to bring and to elect to bring a claim in either jurisdiction. The fact that it was exercising him specifically was whether on the pleaded case the individual was actually seeking both sort of the information, the categories of information, plus the copies of information, and sort of there was a sort of factual matrix that turned on that. But the wider issue that I found quite interesting was how it had actually ended up in the county court at all. But certainly the court was seized with it and was dealing with it, and indeed he was sort of considering his judgment. So although it seemed it seemed a sort of a cack-handed way for the claimant to approach it. Part of the rationale was they'd done it before and been paid off, and that's why the defence was along the lines: this is spurious, this is vexatious, this is simply abusive of the court system. But nonetheless, it seemed to be a freestanding right.
Yeah, thank you for that information, Chris. That's really interesting.
And I first came across that because exactly similar to what Chris has just mentioned, where you have employees who mention these things. And this was mentioned even before we had enacted on the SAR. As part of the SAR that came through in writing, this individual had mentioned that should we miss out anything, excuse me, even in, genuinely miss anything out, he would go as far as pressing for a court order against the employer. And that's when I happened to check. But then what I didn't come across in any case was a case where that had actually happened and been seen through all the way to the end and resulted in a court order. What I was coming across was a lot of, fines because data breaches had happened, but never something in relation, never a court order in relation to an SAR not being implemented entirely, exhaustively.
Yeah, I mean, it's not a good thing, but it's certainly interesting from a DPO side of things. So thank you for that information.
That's all right.
I think there's a very good reason that Sanjay, you're not finding decisions, although I'm pontificating and I don't know, but I suspect the rationale behind it is one of quantum, because whatever the decision on liability is probably dealt with as a small claim. So the value would be under £10,000. So those decisions tend to be not dubious, but very much less influential. They're less reportable. They don't tend to be cited as any great authority going forward. And of course, they wouldn't. But they're not superior. There's no court over which they can sort of lord rights. So they can be sort of one-off decisions. But that's why people would tactically usually go to the ICO, because if you're not going to recover your costs, it doesn't matter if you're successful. Why would you not go to a cheaper venue that's geared up to deal with enforcement, or and uphold complaints and so forth? So it seems an odd thing to do. But as I say, I think there was a rationale for it.
Yeah, because I mean the ICO, the financial impact they can have and the reputational impact it can cause is can be that severe that you wouldn't think anybody would go to that extent. But hey, there's more surprising things, I'm sure.
Any other questions? Genevieve?
Yeah, I've got one question which goes back a bit to just what we were talking about in WhatsApp messages. And I'm sort of a little bit partly just curious because I don't use it for work myself. I mean, I just use email or the telephone. And also, but I was thinking that, most people, and I don't know if this is certain, but most people use WhatsApp for personal messaging. So probably not work-related things. So they wouldn't necessarily send through WhatsApp, anything to do work. I'm not just talking as a lawyer, but even salespeople, things like that. I don't know how much it is used. And then, so I'm sort of asking about that. And also, I've been a bit surprised when they've been talking about politicians recently. All sorts of investigations have been going on that a huge amount of politicians have been using WhatsApp and personal messaging for communication, which surprises me a bit. So how often is this, is this mode used, and how often does it come up, for example, in a subject access request?
I mean, with WhatsApp, if they were to put in a subject access request, you don't need to send them the trail of the conversation. You only send them the part where their personal data is used. If their personal data isn't in that message, you don't need to send them a copy of it, because the right that the data subject has is to see a copy of the personal data that you hold of them, not a chain of conversation.
Okay, so the content becomes, as you're saying, apart from all, you know, the personal details of the names and addresses and anything else, the actual content and the meaning just sort of is put to one side to some extent.
Yeah, you just need to give them a copy of what personal data you hold. You surely wouldn't need to send them a chain of a conversation, but if their personal data maybe sits in a body of an email, you know, that's something different, which is why I say to keep opinions out of it, factually remain. So yeah, never write an email or anything that you wouldn't be comfortable with whoever you're talking about with them seeing.
Yeah, all right, thank you. Thank you.
If there's something like if you have a legal obligation, that's another right under GDPR. Say if there's a legal obligation where you wouldn't share that, or, you know, if there's a criminal investigation, if the criminal themselves said, I want to put in a subject access request, you know, the ICO aren't going to say, well, you know, you've got to acknowledge the subject access request. That there may be other things that you can rely on, such as legal obligations outside of the GDPR, that you could use as a genuine reason that you can't share that data. And that's a decision that you document.
All right, okay, thanks.
Lyndsey, just touching upon the last bit that you covered, where there's a legal obligation. So obviously, between a client and a professional service provider, which most, you know, we are in this forum, there would be so much that's covered within that protection, isn't it? Because anything that's discussed between a client and a service provider is privy to to high levels of confidentiality. Now, where, say, as HR consultants or employment lawyers, we've advised a client, and yes, we would definitely restrict those things to email. Are you saying, and we've named this particular individual who's put in an SAR? My understanding is that that level of advice isn't disclosable because the client is protected.
If there's something under
because they're seeking advice.
Yeah, if that was the case, what you'd do is you'd look into employment law, identify if there is something in employment law that would prevent you from disclosing that information. And then that's a legal obligation that you could use, you could assess, get some expert advice from a data protection officer. And then, yeah, you could document your decision. So if there's a particular law outside that may apply to not breaking confidentiality, or, you know, something like I said, if there's been criminal activity, look into any other law that may apply and prevent you from disclosing that information. If there's no law that prevents you from doing it, and it's just a client confidentiality, but there's no law that applies, then, you know, the subject access request would still apply. But always seek advice if you decide not to share data in a subject access request.
And that for that we would turn to a GDPR specialist or to ICO. Yeah.
Either or. The ICO, they'll give you links to things and they'll give you real top level advice. But if you've got a DPO who knows the organisation and has time to actually delve deeper into it, then they'll give you suitable advice.
Thank you.
Sandia, just to pick up on what you're saying, Louise, here. I've had some experience with this and with the ICO, and I think from a HR perspective, you do need to be careful, because the feedback we've had previously is that HR advice isn't covered by legal protection. You're only protected if you're given advice as a solicitor. So this is why when we're in that kind of situation, we try to say, well, if there's something that potentially you don't want to be disclosed, always take advice from a lawyer in conjunction with HR, so it's got legal privilege. If there's not a lawyer involved and it's just advice being given by a HR advisor, consultant, etc., that probably is going to be disclosable under a subject access request. So yeah, do be careful.
Yeah, thank you. Any more questions? I'm sorry, I was talking again when I was on mute. Not helpful, is it? Chris, do you have any more stories for us on this matter? Sorry to put you on the spot, but I think you've always got.
I would be interested, Lyndsey, in your talk, just to understand sort of tactical considerations that sometimes come into play in dealing with responses, because often from an employment perspective, you get requests made during employment, often as part and parcel of any disciplinary or performance review, or if somebody thinks there's a redundancy exercise and something nasty is looming, and then possibly as part of an appeal or post-termination. And then there's the pre-litigation stage and then the in-litigation stage. So I sort of compartmentalize how I would approach things, because I can be a lot more robust if we're into litigation, because I can talk about sort of legal professional privilege and other matters, and saying that this is a phishing expedition and an attempt to sort of front load early disclosure, and it will be so forth. But the in employment particularly and immediate post termination is more difficult. WhatsApp is an interesting issue because most of my clients don't communicate that way. So I would not see the employer fundamentally as being either a controller or a processor of that, providing it's more social. But of course it does blur, the lines sometimes do blur. But I just wondered if you had any thoughts about tactical considerations as in responding, where you essentially have that sense that it's been lined up with litigation in mind.
I mean, referring back to the other laws outside of the general data protection regulation, if there are any other laws such as employment law or anything that prevents you from sharing the data, then you consider that in your decision in what you can or can't share. But in relation to kind of employees, it applies to past and present employees, which if you have a retention schedule, if there's no reason for you to still hold that data, delete it, because it's less information that you've got to source and provide a copy of. And it's one of the principles under the general data protection regulation, is the limitation. You can't hold data for forever. You can only keep it, as they call, for as long as necessary. You can keep that data for as long as it's necessary that you need it, but outside of that, you have no right to hold it.
Yes, that is one of those friction areas for certainly for lawyers, because as you say, most businesses will not want to retain information longer than they have to, and they'll have a shelf life, and then they'll be hopefully on it and quite robust in going through that and sort of eliminating data.
Yeah, too many people keep data just in case.
But I was going to say, the lawyers will often say, if you think there's a claim looming, and that claim, for example, could be made with a limitation of up to 6 years, do not delete that information, because that has an evidential quality that would need to be assessed and adjudicated upon, possibly by the courts or even in a mediation. And it's fairly robust advice to say, shred it as soon as you can. Mostly you're a lot more cautious with those particular matters, even if it means sort of departing slightly from what a standard position would be.
I mean, what is required under the general data protection regulation, and from having a number of new DPO clients that we onboard, one of the most common things that they don't have when we carry out we do like an overall assessment of the organization as a whole, and we look at exactly every single little thing where GDPR would apply, may apply. what they have, what's missing, what they need, what needs updating, and so on. And one of the most common things that organisations don't have is a record of processing activities, which is essentially, it's a map. It details categories of data you hold, who the data is about, so employees, clients, whichever. How long do you keep it for? What's your lawful basis of processing under GDPR? So that could be consent, legitimate interest, legal obligation, vital interest. You list that there. Who do you share the data with? And what safety mechanisms do you have in place? So that's a few things that you would put on your map. And that's the most common thing that people don't have. But yet it's the best tool at your fingertips, that once you go through the pain of completing it, it'll help you in so many ways, because it'll make you reevaluate how long you keep certain types of data with, who are you sharing the data with, do you need a data sharing agreement or international data transfer sharing agreement with them, do you have one? It just makes sure that you are compliant. But not only that, if you get a subject access request, you'll be able to look at and know where it's been shared to. Where it's stored and how long for. And if you're sticking to the Bible of your records of processing activities and you're not going over the retention period that you've applied, then you'll have an idea of how much information you're going to have to source.
Stunned silence.
Yeah, I was going to say, does anybody here have a
Just
record
sounds
of
like a
processing?
mammoth assignment.
Yeah, I was just going to say that the mapping idea sounds to be really, really, really useful, because then everybody knows exactly, what you're doing, and that structured approach, I'm sure, is extremely useful for all sorts of businesses and situations.
Yeah, and people don't realise it's actually a requirement. It's not a good to have, or it's an excellent tool, like I said, but not many people realise it's actually a requirement under GDPR that you have a records of processing activities. How detailed it is down to you, but you should have one.
So is that something that you almost recommend, or talk to your new customer or client almost immediately? Have you got something like that, or recommend that they put it in?
Yeah, what we do is I created an assessment, audit assessment it is, and it covers each individual part of the GDPR. So such as a part of staff awareness, so it'll have you trained your employees? Do you do refresher training? Do you put in their job description the requirements to abide by GDPR? Do you have a privacy notice for your staff members, and so on? Then I'll have policies and procedures. Do you have these policies, yes or no? And yes, a records of processing map is always in there. And that sticks out like a sore thumb, like I said, because it's very common that that's something people don't have, and they haven't quite realised it. It's not something, like I said, it'd be a good idea. You need to have it, but it's a task that takes, it's not a quick drafting up a subject access request procedure for people to follow. It's a fairly large task if you haven't got one already, or if things are a bit unaligned or here, there and everywhere, it's going to take even longer. But yeah, it helps you in the long run, and it makes sure that you comply to GDPR. And everyone goes,
From the sounds of it.
I don't make the rules, luckily.
From the sounds of it, because it needs updating as well, because it can change who you're sharing data with.
It's a live document.
Yeah, and that's, yeah. So yeah, it would be an ongoing exercise.
Yeah, for some of my clients, I maintain that document is a live document for them. So I have regular meetings with them, so I always know if there's new clients or any changes and so on, or projects where they may need to share data. So I update it as a live document, where other clients who are slightly smaller, they haven't got as much of a high volume data processing going on. They're happy to maintain it as they go and wait for updates from me to say, do you know that you can't keep this type of data for this amount of time? Or, like I said, the standard contractual clauses that used to be able to be relied upon have now changed. So then, you know, the update with the information I give, but others want me to keep it updated.
Thank you. Interesting. Any other questions or comments?
Hi,
Natasha.
hello. I wanted to just pick up on something you spoke about a little while ago about enforcement of ICO. I know we've talked a lot about subject access requests, but I guess a lot of us here, we deal with them really regularly, either you know, raising them or responding to them for my part. And I just wondered, when you said about, you know, the ICO would investigate if there's been a breach of the regulation, because obviously the requirement is there for the business to provide the personal data. And my experience is that organizations do get very panicky about them, and it's, you know, the time pressure, it's a lot, it can be really intense responding to one. But in terms of, if an organization doesn't respond, or sort of does a bit of a half-hearted attempt, doesn't really provide everything they should, in reality, what powers the ICO has to kind of really make that happen? My experience is that they don't really do very much about it. I just wondered if that was, you know, everyone else's experience, if that's quite common. That's what I've sort of found, that their enforcement action is quite limited, unless, you know, we're talking about these kind of things, rather than when a company maybe, you know, there's a data breach, if you like, they seem to be, the fines are in place for those sorts of things. Yeah, so I just wondered really what your experience of that was, or anyone else's. I mean, because it seems quite contradictory that there's all this pressure on the organisation to do it, and they really panic, but actually I don't think there's much of an outcome if they don't.
I mean, it's very much, it'd be a risk-based approach from a business to make that decision. Because in terms of the ICO, they have the power and the ability to impose a fine. They take a tiered approach in terms of the fines and implications that they enforce. But making a decision to kind of not fully allow a subject to exercise one of their rights under GDPR, I wouldn't recommend it, but that would be a approach decision that a business would have to take.
But I just wonder whether, when you said they look at, you know, the type of breach, the level of breach, that sort of thing, but is there a standard, is there like a baseline of, you know, if you just haven't responded or you haven't dealt with it properly, this would be the, you know, what they would actually do as a enforcement action for that?
It's a case-on-case basis, and there's a good reason why. Is that under GDPR, you've got different types of data. You've got personal data, and then you've got sensitive data, which is things like medical information, or you know, criminal information, or political opinions, and so on. So they'll look at it. They'll look at what type of data is involved.
Okay.
They'll look at how much data is involved. They'll look at the type of processing. So they analyze it on a case-by-case basis. So there's no bottom line or midline of, if you don't do this, if it'll be that. If you do this, it'll be the other. You know, the guidance that they give on fines is that it's, like I said, up to 17.5 million, or 4% of a global annual turnover, which would be for the big boy fines, which Meta seem to feature quite a lot. You think that would get a better data protection officer and legal team, wouldn't you? But yeah, it's based on base cases of how they would apply it.
Okay, thank you.
No problem.
Lyndsey, you just touched upon medical information, and obviously we tend to seek occupational health reports. And when we get an occupational health report, it's always password protected.
Good.
Now, what I'm going to be asking is something that's very specific. So when we get an occupational health report, that gets filed into the employee's record, be it the HR database system, which is online and password protected and all that. The report itself is password protected. So say, what do you know, or have you come across a situation where, being an occupational health report, there is medical information there, we want to hold on to it, because it's got such long-term implications sometimes, because sometimes the referral we're making maybe even 5 years later has to be linked to a referral that's been made earlier, just because it's a longer term condition or whatever. Yes, we should not be holding on to data that's for anything more than ideally 6 years. But where it's password protected and filed away, that report itself, is that going to be considered a breach of data where you're holding on to something beyond 6 years, even though it's been password protected? And unless the person shares that password, it's not exposed, really.
Password protecting it would cover the integrity principle under GDPR, because everything that you have needs to be stored securely. So that's one side of GDPR. A different subject and another side of GDPR is holding data longer than necessary. So if you've got it for longer than you need it, it doesn't matter whether it's password protected or not. It'd still be in breach of GDPR. If it wasn't password protected and you had it longer, there's two different problems there.
Yeah. Yeah, that's a tough one, because some employees who worked for many years and who've got ongoing conditions, personally,
Surely
I don't
there's an
think I'd be
argument.
advising. Yeah, I don't think I would ever be advising my client to just delete that
There's lawful
from the database, because sometimes even your occupational health providers change because you're working, and you're not going to be able to access that information, that historic medical information at all.
I mean, if you have medical information and there's a purpose of having it, so there's different lawful bases of processing. This again is where the map would come in handy. So one of the bases of processing is a vital interest, as I mentioned before. If it's within that data subject's vital interest, such as having say if they had epilepsy, and you need to be aware of that, it'd be within their vital interests that you have that information. But if you've got no reason at all to have it, that's when it would be a breach. But if you have a reason to have it,
I
then
think
you can use a lawful basis.
I think we'd be arguing that if this person is covered, or that condition we suspect is going to be covered under the Equality Act, we've got to demonstrate that this person has been supported for the length of service, etc., all of those arguments. Then I think having that occupational health would, report, even if it's more than 6 years old, and where there've been more referrals since then, would be so relevant to draw that link. And for an employer, that's vital, I would think. So
yeah, it could come under vital interest or something called legitimate interest, which requires a documented assessment. But again, that map is why it's such a requirement, because you'd document under category medical information. You'd have your purpose of processing. You'd decide whether it's vital interest or legitimate interest. You document that. So yeah, you'd have to have a look at the categories of data. And as an example, you'd identify a lawful basis of processing and apply it.
Yeah, what I'm getting at is I think the 6-year rule, it's very hard to apply it bluntly to absolutely every piece of sensitive information that you hold.
Yeah, I mean, that's why you've got legitimate interest. It's a bit of a tool that you can use where if there's, an exception or a particular situation where it would be within that person's not vital interest, but it'd be within their legitimate interest for you to have that information. You carry out a legitimate interest assessment template and you document it to kind of document why you think it's within their legitimate interest to have that data, and you'd put it on your map. But again, seek expert advice on that, and they'll be able to advise you, yes, you are correct in thinking that, and this is what we'd recommend you include in your legitimate interest assessment if you rely on that, or it sounds good, but actually there's no right under there to have it. It would be seen as having it just in case. But by the sounds of it, I think there would be a legitimate interest.
Yeah.
Yeah, luckily there's 6 different lawful bases of processing, not just one.
Right. Interesting. Any more questions? Any more comments from anyone? If there are none, I don't mind wrapping up the meeting earlier. It's been really useful. It's been useful, definitely, and there's always something new to discover and learn, isn't it? But yeah, we've got, I think Catherine has already shared Lyndsey's details. So if you've got any questions, please feel free to continue the conversation. And I don't yet have a guest speaker for the next roundtable, but obviously we'll be in touch with that. Any comments or questions, please feel free to email one of us, or we'll be in touch.
I know data
Lyndsey,
protection.
thank you. Thank you so much.
Yeah, I know it's not the
I'm
most
sorry, you were saying
exciting-
something.
I'm just saying, I know it's not the most exciting subject for people to listen to. In fact, I think my words yesterday to the attendees at the end after a 3-day training session, 3 hours, sorry, 3 days would be a bit much, a 3-hour training session was, okay, you can run free now. So yeah, any questions, reach out.
Thank you. Thanks a lot.
Okay. Bye,
and
guys.
have a lovely day.
You too.
Thank you very much.
Thank
Bye.
you.
Thank you.
Bye-bye. Bye.
Thank you. Bye.
Bye.